place. That brings me to the next topic, and I think this is an interesting topic, especially when it comes to India. This deals with structuring a litigation finance agreement or a transaction in India. Now, of course, the structuring lawyers and the funds lawyers, foreign exchange lawyers on the call, or even clients who have dealt with foreign exchange, understand that India is not an open market. It often can get challenging to get into transactions where foreign exchange is involved. But to put it in summary, there are various ways in which claims get funded. And as Sindhu pointed out in the beginning, they're generally non-recourse. And also there can be a combination of all kinds of deals where you can get one single case funded, a claim, or there can be multiple claims put together, or there can be a single award or a decree which you are recovering, or it can be multiple decrees which are plugged in together. There are also combinations at times where you have multiple claims and decrees both all joined together in one portfolio. We've seen, of course, the HCC and other kind of deals where, Patel Engineering, where there are demerger, slump sale, asset sale kind of an agreement, more equity and debt in nature. Then there is, of course, funding the insolvency professional, where he's going and litigating and recovering claims of the company. There is partnering with banks and financial institutions where you're helping their portfolio to recover money. So there are many such ways to get into. And of course, you can do both offshore and onshore. Offshore, of course, in India for a foreign funder, a lot of restrictions. FEMA is the biggest challenge, but assignment of resolution sum generally is a way which we've seen deals in the market happening. Onshore, there are various structures you follow, securitization and IAF. The combination of two is something we've seen, securitization trusts. NBFC is a model which is functioning, where there are NBFCs which are currently doing litigation finance onshore. This, of course, increases your ability to even take working capital assistance or to maintain security for the funder. But all in all, when you come in India, of course, you need to be careful of several laws like FEMA, the money lenders regulations, SEBI, RBI. So it's a complex bunch when you structure in India. Is it the case like this in international markets? Sindhu, what do you think? Is it as complicated as India?
It really depends, I think, on the type of dispute and the jurisdiction or jurisdictions, as often the case involved. At the end of the day, the sky is the limit in terms of how you structure a financing arrangement. It's more practical in the sense of what works best for the claimant as well as for the funder and all the parties involved. I suppose whatever you choose, as you pointed out, you sort of want to make sure that the structure is enforceable and all the parties are able to perform their obligations under it. Beyond that, you can be pretty innovative. I think the simplest structure is, a single case funding arrangement where funder, claimant have a bilateral agreement where the funder agrees to pay the legal fees and expenses associated with the litigation. And this is a single case. Even here, internationally, variables, right? For example, the law firm and or the claimant can join in the funding of the costs of the case and thereby participate in the recoveries made. Then you can have some sort of a portfolio arrangement where the litigation fund invests in a set of claims, either held by a claimant or by a law firm. Aggregating claims can make it much cheaper because investing in a portfolio is obviously a little bit less risky for a funder than investing in a single claim with a binary outcome. Portfolio financing is also, I think, it can be a way in which you can get defense funding because you can add in a few defense matters to the overall portfolio. You can also use it as a way to get funding for, operating costs, overhead expenses if you're a law firm, and so on. Basically, so long as you've got enough affirmative cases with this high enough value, that can be used to offset all these other costs. Then the other sort of variable, I suppose, that exists is where you see funding tied to a non-monetary win. So a win that, basically allows a party to hold some right or asset which is then tied to an income stream that can be used to share with the funder. And this is again very, very helpful in defense funding. Let's take a very simple, breach of contract, a breach of a distribution agreement kind of a scenario where the defendant is the distributor. A win at the end of the day, and say there's a wrongful termination, by one of the parties. Now, a win at the end of the day for the defendant here might be the right to actually continue to distribute that product in a particular geography. It's very easy here for a funder to actually tie in the funding to the income that's ultimately coming from the distribution, and this can be used by claimants and defendants. And I suppose the last, and just moving on from simple financing is sort of what you said, where you sort of try and monetize claims outright. So whether it's an outright sale or assignment of a claim, and in common law jurisdictions that's typically restricted to the insolvency scenario, but in civil law jurisdictions that can be used more widely. Or you can, of course, just sell the underlying debt. So say there's sort of a bunch of bonds that give rise to a claim. Instead of selling the claims, just sell the actual bonds themselves to an investor and then let them litigate it out. Obviously, there are huge advantages to this sort of structure. For the claimant, you get money upfront, and again, the money is not tied to anything. You can use the money for whatever purpose it is that you want. I mean, just a sort of, I think, snapshot of some of the structures you see internationally, but there are numerous variations of each of these structures, and it really depends on the jurisdictions involved.
Thanks, Sindhu. It's very interesting to hear because, if I can draw parallels to the Indian situation, the last part which you spoke about seems to be quite regulated in India. We have the Securitization Act, which works exactly for this kind of cash out, if I may say, where you take in securitization assets, and you can do that to even non-banking assets in India, where you can just start a securitization trust through the SCRA and the SEBI regulations. So very, very useful to understand that India and internationally the similar kind of framework is possible and structures are possible. But Tom, coming to you now, one is the structure, but then there is the tax risk and there is the currency risk. How do you tackle with these elements in a funding contract?
Well, I mean, I think, Pratik, it's pretty similar in terms of tax and currency issues for us as it is with any other foreign investor coming into India or indeed operating globally. And India does have some particular complexity around that, but so do other markets that have strict capital controls. And we have to navigate that. I mean, really at the end of the day, we need to make sure that we can get the money in and get the money out without being unduly penalised. And where the opportunity is strong enough, we will find an appropriate way to do that. It's far too complex to get into all the details now, and I'm not sure I can give away all of our secrets in any event. But it's like any other investment business, where the opportunity is there that you engage the right advisors and you make sure you do it appropriately.
Well, so Tom's not going to give his secrets out, but we're going to try to probe him more and try to get some more secrets. One more to you, Tom. How do you protect the recovery of an award? Especially in an India context, securities are difficult for foreign players. How do you protect your return?
So we typically do that. We take a proprietary assignment of the proceeds of the award, but also sometimes of the award itself. And we require that those proceeds are paid into some form of escrow account or lawyer's trust account. So that's how we try to protect those money flows. Where we can register security interests over these sorts of assets, we will do it. I think there's a question mark in India as to what we can and can't do there. But again, it's about working with what we have and ensuring that we're mitigating our risks. If there is a higher risk involved, then that's likely to be reflected in how we price our returns, frankly. Interesting.
Sindhu, coming back to you, and I think the audience would like to hear both of you all quite a bit in this because it's crucial subjects. In India today, insolvency is a big market. The insolvency laws have evolved, and insolvency is seen quite a big uptake from the speed and expedition in which the cases are disposed. How do you look at funding claims of companies under insolvency?
In many ways, the structures are not sort of dissimilar, and the scenarios are not dissimilar to what the overall structures we kind of went over. I mean, funders can fund. We can fund insolvency practitioners on a case-by-case basis, or if an estate has a number of potential claims, we can fund some or all of them on a portfolio basis. In insolvency particularly, it's helpful for the IPs if the funding can also facilitate the administration of the estate itself. So if the funding can cover not only the legal fees required to advance the claims, but also any ancillary defense matters and any administration costs and the IP's fees itself. In a restructuring, so like a Chapter 11 sort of a process, and again, it's not uncommon to see litigation funding covering some of the debtors' operating costs as well. Almost venturing into the territory of a DIP financing or a DIP loan. Now, I suppose what's unique about insolvency is most common law jurisdictions will also allow IPs to assign and sell claims outright, which is typically, outside of insolvency, you just can't do. Funders can buy these claims, either for an upfront price, or we can sort of pay a nominal fee and agree to split the proceeds at the end. Either ways, this can be quite interesting for IPs. With an upfront fee, it's obviously helpful because you monetize the claims upfront. Even in the second case, it de-risks the IP somewhat because the claim's been assigned to the funder, so they're no longer on the hook for any adverse costs, which otherwise they would personally be on the hook for. And for funders, if you think about it, it gives them a significantly greater amount of control over the running of the case, which a lot of funders like. With insolvency, I mean, there's a couple of things to think about irrespective of jurisdiction, right? One, I think, is ATE. For obvious reasons, security for cost applications will be very frequently used in insolvency disputes. So it's quite important to, I think, work with a funder or sort of, make sure that there is some sort of ATE insurance in place or adverse costs are just somehow covered. Priority will also be very important for a funder to ensure that they get paid out of the recoveries made in the litigation ahead of the other creditors in the estate. And to ensure that it's important that the right steps are followed, I suppose, and this really varies across jurisdictions. It can be getting the consent of the secured creditors, or it can be getting court sanction. I suppose whatever it is, it's important, I think, both for sort of the IPs as well as funders to be quite mindful of it and navigate these rules carefully, jurisdiction by jurisdiction.
Interesting. So I think insolvency is another area I think the practitioners and the counsels on the call need to explore where Tom and Sindhu, their role can be played. IRPs should consider insolvency financing to explore what is possible. Tom, the last question to you in this theme. When do you get out of a deal? Is there a situation where you terminate? Is there, or once you commit your funds, it's committed?
There are circumstances in which we can terminate a funding agreement, but termination for us is absolutely a nuclear option. Because the funding is non-recourse, that means if we terminate, we lose our investment. And potentially it means we're still on the hook for adverse costs as well. We have to pay the other side's costs if the case is withdrawn. So it is very, very, very rare that we would terminate. And we would only be able to, in circumstances where there's been a material deterioration in the prospects of success or recovery. So, maybe the respondent has become insolvent. Maybe there's some fatal evidence that's come to light that destroys the merits of the case. And in those circumstances, really there is no interest for anybody in continuing with the case. And rather than terminate, the most likely outcome there is that we'll work together with the funded party to try and achieve some sort of settlement, if we can. But of course, if we can't, then we may have to walk away from it. As much as possible, we try to avoid this by front-loading the issues as much as we can. And as anyone knows who's been involved in a due diligence process with a funder, it should be, and it is, very detailed. And we do try and anticipate the defences that are going to come up. We interrogate the evidence. And when we're looking at the financial capability of the respondent to pay, we try to ensure that it's going to be sustainable in 2 or 3 years' time, or however long it may take.
Thanks, Tom. Badri, we've heard from the funders, but you are one of the GCs who has good practical experience on how this works. Can you tell us from your learnings? Can you tell us from your experience the challenges you faced, the considerations? The audience wants to know, if they want to get into a deal, what's the tip to them?
I think very interesting. It's a kind of a mixed experience, many times frustrating, but nonetheless, it's a path breaking. I think that's the way I would put it, because it sometimes it puts a lot of strain on the way in which we are going ahead as such. But anyway, the road is not going to be smooth. One need to go about it. I speak from an infrastructure point of view, infrastructure company's perspective. Usually what happens is there'll be 4 kinds of monies that are realizable. One is arising out of the claims, second through litigation, and third is through the arbitral awards. And fourth is a kind of the other miscellaneous bank guarantee encashments, things like that, which are to be contested. I think these are the type of cases which are there in the books of every infrastructure company as such. As Sindhu was mentioning, that we tried all types of structures, including that of the portfolio, mixing with the A plus B plus C plus D, and all the 4 things as such, etc., etc. But finally, what happened is that, okay, the structure part of it is fine, and everything is facilitative. We can do it. If there is a mindset, obviously we can do it. But there are about 4 obstacles which we really faced wherever I worked with in terms of the financing on 4 fronts. The first and foremost is my client himself. Whomsoever with the client is a major obstacle for me. Because the moment I sound that it's going to be a third-party financing, obviously there'll be kind of a ears up, and he'll be really little suspicious about how I'm going to do about it and how I'm going to realize it, and what are the kind of rights and obligations which will have it. So there are very many instances in which the clients themselves become a kind of an obstacle to the kind of a path we are into. It takes very tough time for us to really convince them as to we are not going away from our rights and obligations. We continue to perform the way in which we are performing, and that convincing is a major ability one need to have it. You take it from me, it's only 50% success on that. Okay. Now the second important obstacle are the courts themselves. Because the courts, the moment we mention that there is a third-party financing involved, even if we don't mention, the other side would make a mention about it, that this has come out of a third-party financing, it's a kind of a litigation which is not really worth the sustenance, etc., etc. I think the courts take a very drastic view. There are very many comments made by some of the judges to which I am a party to. So that becomes a kind of the minds of a third-party financing vis-a-vis the litigant is not really looked at in a positive way, the way in which we expect it to be seen. The third is the financial institutions. Many a times the financial institutions have got a kind of a mindset that the third-party financing people are taking away the chunk and they are leaving very little for the financing. They call it a banks or a financial institution as such. So they become a stumbling block in terms of giving me the kind of an NOCs which I look at it from time to time. Because unless and until I get an NOC for an infrastructure company, I cannot go for a third-party funding. So there are instances where the banks themselves wanted to have the cake and then eat it too also. That's a third thing. The fourth and the most important thing is the board itself. See, as I said that we have types of claims. As Sindhu was mentioning that you can create a portfolio, strong to weak, or one bucket to another bucket, we can create it. Say, for example, there are about 100 cases in the portfolio of a company. 25 are going to be strong, 25 are going to be weak, and the remaining 50 are going to be somewhere in between. The chances of winning and losing are fairly good about it. The board comes heavily on the company stating that when these 25 are good and the remaining 50, out of which another 50%, that is another 25 are going to be in your favor, why are you going for a third-party funding with a huge cost? So you need to explain the kind of a proposition. As you know, in India, the court's kind of an outlook or the arbitrator's outlook or how long the case will go on. These are some things which are not predictable as such. Today, we are looking at a third-party funding as an option for a cash flow situation, not a kind of the thing whether I win or lose. I think the kind of a mindsets are different, but it's very difficult to convince the board in terms of why I'm going for infrastructure financing. Anyway, the shareholders and other things being the other buckets as such. But these are the four kind of a difficulties which we faced. And apart from the structure can be a simplistic structure, keep all the claims in the company itself, and then go about it with a third-party financing with the kind of necessary documents, deeds, etc. That's one structure which I've tried. Fairly simple, but it didn't work. But obviously there is another structure in which a kind of an SPV has been created where things would get into that SPV and the funding will come into that SPV and the proceeds will be utilized. That also didn't work partly. But it's a kind of a mixed bag somewhere. It's not that impossible, but definitely it is something which is workable. And when we can plug the holes in terms of convincing the clients, the courts, the financial institutions, and that of the boards, with respect to boards, ultimately there is a kind of a culture we need to set in, as you were mentioning in your opening remarks, about how we go about the third-party financing. That thought need to be crept into. A kind of an institution has to be set up, if not a kind of a forum. A kind of an institution has to come up, and a kind of a legislation need to be brought in to see that these things take a real good shape. Nonetheless, I would like to sum up this point by stating that independent of the structures are fine, they're workable. But the kind of a stakeholders with whom we deal with, I think they are the major hurdle. That requires a different set of skills to really convince and go ahead in the path of third-party financing.
Thank you for those points, and I think it's a very well taken comment. We understand these challenges, and I think that's the very reason where market players have now come together to do something which is very similar to the UK. And in days to come, you will see people voicing, educating, and spreading words. So concerns from all quarters are addressed.